Hello, neighbor. I'm Robert Burns, and welcome once again to another edition of Sound Off Louisiana. And on the last feature, I said that would be the 10th and final episode of the Stanford OFI matter. But that was going on the premise that the attorney for the Stanford victims, Mr. Phil Price, was going to behave himself. And in my firm opinion, he has done anything but behave himself in the aftermath of that trial. Now, on August the 9th, which was Friday, 1 week ago Friday, he had let the reporters know that he would only be making comment, quote, if I win, unquote. But I guess over the weekend he just mulled it over, and so on August the 10th, which was the Saturday after the verdict, he issued a press release, and that caused WBRZ to come out and interview Mr. Price. And I'll tell you what, we're going to break away right now because we're going to dissect this interview in depth. Let's break away right now and hear one of the first things he had to say in that interview. We'll be right back.
Philip Price has been representing around 900 people fighting to get the money that was taken from them. In a release on Sunday, Price says the system has once again failed them. He said they gave the state commission documents that showed that as early as 2004, that the banks were alerted that the transactions weren't safe, but the public was not.
It made no sense to me that all of a sudden you could have a situation where unsophisticated people like the Exxon retirees that lived in Baker and Zachary and Central could invest in them, but on the other hand, that banks in the state could not invest in them. That made absolutely no sense.
All right, you just heard Mr. Price say that it made no sense to him that the banks would be told you can't invest in these Stanford International Bank CDs, SIB CDs, and yet individuals could. He said that makes no sense to me. Well, I can only assume that Mr. Price put earplugs in his ears and did not listen to a word that came out of John Ducre's mouth when he itemized off, when Mr. Blunt said, would it be acceptable to invest in Apple Computer as a bank? No. Would it be acceptable to invest in Starbucks? No. There is a distinction between what a bank can and cannot invest in, separate and apart from individuals. And look, Mr. Price says this makes no sense to me. That is, what he's doing is pandering to a television audience that he knows doesn't know the ins and outs of this. But trust me, he knows, okay? How do I know he knows? He used to be an OCC examiner. That's Office of Comptroller of the Currency. They regulate national banks. They do the same thing that the FDIC and the OFI do. They just do it for national banks. And that's in his past. He was an OCC examiner. So either he was incompetent as an OCC examiner, or he's being less than candid when he says, that makes no sense to me. I mean, it's really galling to see him say that, especially given the great lengths that the defense team went to distinguish self-directed IRA, investing what you want. A bank cannot go investing in these things, and that would include things like Apple stock. Now, I'm not going to belabor the point because it was covered ad nauseum throughout our blog post on that. So, look, this was a civil trial, okay? And in order to prevail in a civil trial, you have to meet what's called a preponderance of the evidence, and that means it's more likely than not. You don't have to prove beyond a shadow of a doubt or beyond a reasonable doubt. You just have to prove that it's more likely that it happened than it did not. I'm going to use a quick football analogy. This would have been a hard case to win no matter what. But Mr. Price and his offense took the field on the 3-yard line. Okay, they got to get to the 13 to get a first down. To get past midfield, they'd get a win, all right? Well, they start out on the 3, a couple of plays, again, a couple of yards, and on 3rd down, they do get a 6-yard run, okay? So they're facing 4th and 2. The 6-yard run, that the only thing they had to try to hang their hat on was that memo that John Travis, who was John Ducre's predecessor, sent out about banks not being able to invest. That was their 6-yard gain, okay? And the defense shot that down, and so Mr. Price and his team decided, you know what, our best shot at winning this is to punt the ball and hope that the receiver of the punt fumbles and we can recover on the opponent's other side of the field and win this game, because they had nothing, okay? They had nothing, N-O-T-H-I-N-G. Graphs showing proliferation of CDs. I mean, they had nothing. And this was a stiff defense. So, okay, back to the analogy. They go to punt because it's their only hope. Well, the Phelps-Dunbar team said, that's fine, we're coming after the ball. And they blocked it, and they scored a touchdown. And Mr. Price is having great difficulty living with the fact that his case was an abysmal failure. Now, he had gone on to Jim Inkster prior to this case even taking place, and he said, oh, the evidence will be overwhelming. I don't think an 11-to-1 jury verdict against you is overwhelming. This was about the most underwhelming case I've ever seen. All right, now we're going to break away for what really hacked me off, and I think it ought to hack any one of you off. Let's break away for just a moment and hear what Mr. Price has to say about this jury. We'll be right back.
Price expressed his disappointment in the jury, saying they took the easy route, and it appears they had no sympathy for the victims.
This portion of the case did not determine damages, and they were smart enough to know that they were going to have to come back for another 2 weeks to determine damages, and so I think they essentially said, we've had enough. We're going to say we're going home. And
all right, let me tell you what is so galling about Mr. Price's statements. This jury had to have the patience of Job, because I'm going to tell you, out of all the hours that they put in over a 3-week period for this trial, I know I can conservatively say that only 35% of that total time was spent in the jury box actually observing the trial. The other 65% they spent in isolation, and that was largely due to Mr. Price. And I'll elaborate in just a moment. Now, there were a few things that was nobody's fault. We had the malware infection that cost a couple hours. We had that video, remember I mentioned to you, that wouldn't play. That cost about an hour and a half. And there were a few other minor things that's nobody's fault. But let me tell you something. An awful lot of the time that jury spent away from that jury box was the direct result of Mr. Price. What do I mean by that? We're talking about hours and hours of arguing over this Doe-Bear hearing that he somehow had it in his head that he was going to have the right to conduct. Notwithstanding the clear-cut wording in the statute that said if you're going to do so, you have to file the motion at least 60 days prior to trial, and the judge has to schedule a contradictory hearing no later than 30 days before the trial. I don't know what Mr. Price, I don't know why that thick skull can't comprehend that, because he spent hours and hours, and he would say, when we have the Doe-Bear hearing, and finally Mr. Blunt said, I don't know when it's going to sink in, he is not entitled to any Doe-Bear hearing. So we're talking hours and hours that this jury is in isolation over what should have been resolved in 15 seconds. I mean, the statute is clear. So that was a gigantic amount of time that Mr. Price, who wants to criticize this jury, is now directly responsible for them having gotten, quote, as he said, got tired and decided to call it a day. Another thing he did, and this spent hours and hours. You got to realize when two attorneys start arguing, and it wasn't just point, counterpoint, all right, follow the counterpoint. This would be like a seesaw that goes back and forth, back and forth, back and forth, back and forth, back and forth for hours, all right? He went on for hours about he would be filing a directed verdict so that the allocation of fault on the comparative fault, he would file a directed verdict for that. You may remember on one of the episodes I said that he indicated that Miss Graham would be going down immediately and filing the directed verdict. That forced the Phelps-Dunbar team and put Mr. Blunt on the spot when he was asked, when can we have a reply memorandum? He said, Your Honor, we can have that no later than 8:30. Well, so Phelps Dunbar goes and burns the midnight oil, costing us taxpayers, but they got to do it because of Mr. Price, okay? And then we get there the next morning, and again, the jury's gone away from this thing. And what does Mr. Price say? Your Honor, I'm withdrawing our motion for directed verdict. I mean, it's unreal. And for him to now slam this jury. And I'll tell you something else. In a previous feature, I had said that Mr. Price's mannerisms would not have gone over well with me as a juror. Okay, by that I mean being obnoxious, his leading questions. And did he ever ask a bunch of leading questions? It just would not have gone, he had condescending questions. It would not have gone over well with me as a juror. And I'm going to tell you something else that would have infuriated me as a juror. And he did this about 5 or 6 times. He would have a witness on the witness stand, and he would say, so are you going to sit there and tell this jury ... And the reason that would be so infuriating to me as a juror is that, okay, what you're saying is if he doesn't say exactly what you want him to say, you're going to make the inference that he's lying under oath. And that's basically what was going on. Are you going to, in other words, he's going to force him into this, the witness into this corner. Are you going to sit there and tell this jury ... whatever may follow that? I mean, I've never seen anything like this. I've sat in a lot of trials, civil and a few criminal. I've spent far more time in civil than criminal. I've never seen courtroom mannerisms that were like this, nor have I seen a judge who would tolerate it. But this judge did. So, as we start to wrap up this feature, and we're going to give a link for an advocate article that also was published based on Mr. Price's press release. He now has indicated that he says, I'm going to move the court. Well, what his meaning is, I'm going to file a motion for a judgment notwithstanding verdict, and absent that, a new trial. That should be dead on arrival. And if this judge does anything other than deny that, I'll stop right there, because that'll tell you a ton, in my opinion. This should be an easy denial by Judge Johnson. And make no mistake, whenever the contradictory hearing is scheduled for this, we'll be there. And we'll certainly we'll certainly put out a feature on Judge Johnson's ruling on it, no matter how it goes. There was also the subtle overture that Mr. Price made that well, he may very well appeal this decision.
Price said that he'll continue to see the case through, and he will determine if an appeal should be filed.
I'm going to be blunt with you. I believe that is nothing more than saber rattling to try to convince the Attorney General's office, throw us a little something, and so it'll keep you from having to incur more legal fees to fend off an appeal to the First Circuit. I believe it's total saber rattling, okay? And Miss Murrell, if you're watching this, don't cave, all right? If he wants to file an appeal, let him file an appeal, and we'll deal with it then. But this has been such an insult to this whole process for Mr. Price to have engaged in the lines of questioning that he did and then take it out on the jury when it didn't go his way. Now, I'm going to wrap up this feature with a couple of more points. A noteworthy attendee on Thursday around noon, when some folk may have thought there was going to be a verdict. If you had been following Sound Off, you would know there was not going to be any verdict anytime soon. But Senator Rick Edmonds did attend Thursday at about noon, sat right beside me. Now, Senator Edmonds, he is now the senator for what used to be Bodie White's Senate district. Bodie White, back when all of this stuff was hot and heavy, Bodie White was the one trying to work with the victims, and he's the one that put out the figure of $2 billion for Southeast area investors. That figure may be accurate, may not be accurate, I don't know, but it was repeatedly published, and as always said, but Bodie White has estimated that the losses to Southeast Louisiana victims are $2 billion. It was my goal to try to get Senator Edmonds to comment on this once the verdict was rendered. There are several theories as to what may have been his motivation to attend. It's possible that when the verdict was read, he may have breathed a sigh of relief of, now I don't have to worry about sponsoring a bill to pay the judgment. That's one possibility. Another one may have been just fully to support the Stanford victims. I'm just going to say we reached out to Senator Edmonds. For those of you who only look at the YouTube videos, you'll need to click on the link for the sound off feature for this, because we're going to put our recorded phone call that was made, I believe, on Tuesday of this last week, but it'll be documented because I also sent a follow-up email that we're going to supply the link to. I would have very much liked to have had Senator Edmonds' comments with regard to this matter. However, he chose not to even reply to either the email or the phone call to say no comment. Obviously, I guess by inference that means he has no comment. And last but not least on this feature, we're going to give you a prelude for an in-depth feature we're going to do with regard to the head of the Stanford's Victims Coalition, a young lady named Miss Angela Shaw Alexander, also known as Angela Kogut, also known as Angela Shaw. Now, she is the appointed head of the Stanford Victims Coalition. And we're going to give you a lawsuit that Miss Kogut, she married into a family that had a small business for over 30 years. They went to sell it. They got, I don't know, upwards of $4.5 million. They decided to invest the whole thing in these Stanford CDs. By the way, just as a note, Miss Kogut and her husband, Michael, he filed for divorce in 2017, and I believe it was finalized in early 2018. But at any rate, we're going to give you a lawsuit that they filed in the aftermath of this. They filed it against a law firm that they say didn't do proper due diligence. It was the same law firm who had closed the transaction on the sale of the family business. It's a fascinating read. It'll give you an in-depth coverage. We're going to highlight some of the features from it. We'll also provide the motion for summary judgment that was filed on behalf of the law firm. And in it, very importantly, in it, her mother-in-law was not in favor of investing in these CDs. Something just didn't, she was uneasy, just didn't feel right. And she was honest enough to make those statements under oath in a deposition. Because then the law firm said, number one, you didn't even ask us when we gave you our review to conduct something more thorough. Secondly, you didn't rely upon it. It's very clear you went on despite the fact that your own mother-in-law had reservations about this, so you waived any reliance upon our report. We'll also give you the document showing that case, it was mutually agreed upon by the parties to dismiss it. Don't know the specifics, but the fact that they filed that motion for summary judgment and shortly thereafter there's this motion to dismiss probably tells you how that went. So, but in our next feature, now hear what I'm saying. I'm giving you the documents for the Angela Shaw Alexander, so you can get a thorough knowledge of, that was probably one of the largest victims, I would guess. $4.5 million is not a small, it's not a couple of nickels, okay? But it will give you an opportunity to have advanced knowledge when we do our next feature leading into Miss Angela Shaw Alexander, aka Angela Kogut, aka Angela Shaw. So we believe you're going to find that to be an intriguing feature, and it'll probably be a few days before it comes out because I'm trying to relax a little bit. That was a very draining trial, and I know it was draining for the jury, and that's why it is so infuriating. Despicable. It's downright despicable for Phil Price to make the commentary he's made about this jury. It's an absolute insult. So I know that you probably have said, well, you're a little bit more teed off, or you're a little bit more angry than you've been in the past. I am. There's no excuse for making that kind of commentary about a jury and blaming the whole thing on them. No, the fault lies in a pathetically weak case. All right, this is Robert Burns thanking you once again, and we look forward to bringing you the in-depth feature on Angela Shaw, aka Angela Shaw Alexander, aka Angela Kogut. We'll have that out for you in a few days. Thank you so much for your dedication.